5 seconds to go. Start. In the case of Internet and Mobile Association of India, SUPRA, the RBI had issued a directive to the entities regulated by RBI not to deal with or provide services to any individual or business entities dealing with or settling virtual currencies and to exit the relationship, if they already have one, with such individuals, business entities, dealing with or settling virtual currencies. Stop. Para. The said action came to be challenged by writ petition filed under Article 32 of the Constitution of India. Stop. The challenge was on several grounds, including the ground of proportionality. Stop. Though the court did not find favor with the other grounds. Stop. Para. In view of the above conclusion, the question of molding the relief shall now be considered. Stop. According to the petitioners, around 86% of the volume of currency notes of the total currency in circulation in the Indian economy was demonetized. Stop. They also stated that the people of India were exposed to undue hardships owing to the lack of financial resources and had to undergo not only a severe financial crunch but were also exposed to other socio-economic and psychological hardships. Stop. The problems associated with the measure of demonetization would make one wonder whether the Central Board of the Bank had visualized the consequences that would follow. Stop. Whether the Central Board of the Bank had attempted to take note of the adverse effects of demonetization of such a large volume of banknotes in circulation. Sign of interrogation. The objective of the central government may have been sound, just and proper, but the manner in which the said objectives were achieved and the procedure followed for the same, in my view, was not in accordance with law having regard to the interpretation given above. Stop. Para. It has also been brought on record that around 98% of the value of the demonetized currency have been exchanged for banknotes, which continues to be legal tender. Stop. Also, a new series of banknotes of rupees 2000 was released by the bank. Stop. This would suggest that the measure itself may not have proved to be as effective as it was hoped to be. Stop. However, this court does not base its decision on the legality of a legislation qua the effectiveness of such action in achieving the stated objectives. Stop. Therefore, it is clarified that any relief molded in the present cases is dehors considerations of success of the measure. Stop. Para. I have borne in mind the submissions of learned Attorney General appearing on behalf of the Union of India to the effect that the objectives of the central government have been sound, just and proper, but in my view, the manner in which the said objectives were achieved and the procedure followed for the same was not in accordance with law having regard to the interpretation given above. Stop. Para. Learned Attorney General appearing on behalf of the Union of India also contended that the issues raised in these petitions have become infructuous and wholly academic as the action of demonetization has been acted upon and therefore the present cases are only of academic significance. Stop. It is necessary to examine the nature of relief that could be molded by the court in this matter. Stop. Para. There are several judgments which could be relied upon in this context. Stop.